Good afternoon, everyone. Thank you for joining me today. Today's topic is addressing a COVID-19 outbreak or infection in your workplace. And we're going to go through what steps you should take if someone in your workplace is experiencing COVID symptoms or has had a COVID diagnosis or has been exposed to COVID and is concerned about that. So just a reminder, I'm not going to give specific legal advice today. This is one of the topics that we do recommend you get legal advice on because it's an area that is fraught with potential liability, both due to ongoing exposure in the workplace, compliance with leave laws, and compliance with the ever-changing regulations that we're getting from OSHA, the California Department of Public Health, and the CDC. I have a chat box and a question and answer open. So if you would like to ask a question during the presentation, I'll try and answer it. We should have time at the end of today's presentation to also do some question and answer. For those of you who don't know me, my name is Jamie Bossuat. I am a shareholder and employment lawyer at Kroloff in Stockton. And this topic is something that I have been dealing with for about 2 weeks now on an almost daily basis with our clients here in the firm. And we have two other employment lawyers in the firm, Carrie Kruger and Velma Lim, and they've also been dealing with these questions very frequently. So just a threshold question employers want to know sometimes is, what are my obligations to my employees and in my workforce? And this is the Workplace Safety and Health Act. It's a federal law, and it requires all employers to provide employees with a place of employment that's free from recognized hazards that are causing or likely to cause death or serious physical harm. And COVID-19 has been identified as one of those hazards. So generally there is this obligation to provide a healthy and safe workplace. The state of California has issued a lot of guidance, which has been endorsed by OSHA regarding putting in place a specific site plan for your industry, identifying hazards and exposures that are common in your particular workplace, and what kind of control measures you should be putting in place. All of those should be followed. But when we get down to more general guidance from the CDC, for example, on what should be done if there's an outbreak, this is the standard we're coming back to, which is a reasonable standard to create a healthy workplace for your employees. And then, of course, there's obligations to the general public and to your customers as well. You also have a duty to act reasonably and to not be negligent with regard to those individuals, not just your employees. So the CDC symptom list changes frequently. Every time I give a presentation, I feel that I have to update it. It started out with just the two, cough and difficulty breathing, and it's now longer. The CDC website today does not specify one or two in combination with others like it used to. It just lists these as the symptoms that could appear 2 to 14 days after exposure to the virus. It's important to be very familiar with this list and stay up to date with what the current symptoms are, because this is how you're going to identify an employee that you should be isolating and removing from the workplace, and you should be communicating these symptoms to your employees so that they are aware of what they should be self-screening for and reporting to you so that you can take appropriate steps. So the list includes fever or chills, cough, shortness of breath or difficulty breathing, fatigue, muscle or body aches, headache, new loss of taste or smell, sore throat, congestion or runny nose, nausea or vomiting, and diarrhea. So that is a very long list of symptoms that is very similar to a lot of other illnesses and conditions. So it does affect a lot of employees, even if they may or may not think they actually have COVID. So it's important as a threshold matter for dealing with illness in your workplace to identify symptoms as quickly as possible. So this includes those measures that have been recommended by OSHA, including temperature screenings for those with a temperature of over 100.4 degrees, and asking employees if they've traveled to an area with a high rate of infection. exposure to an individual in the household or someone that they see regularly and closely who has tested positive or perhaps even has symptoms of COVID but is waiting for a test result. And then that list of symptoms. So the employee should be asked either at the beginning of their workday to self-screen and report that they don't have any symptoms, or asked at the workplace when they arrive whether they're having any symptoms. And you can do the temperature check at your office, but the guidance also does allow you to have the employees check their temperature before they report to work and then tell you that they did not have a fever. Also, these requirements should be applied to your guests. So when making appointments, it's a good idea to inform them of your policy that you'll reschedule their appointment if they are experiencing any COVID symptoms, or if they've recently had exposure to an individual with COVID, and if they're experiencing a temperature. And that's going to reduce the exposure in the workplace. Employees should be asked not to come to work at all if they're experiencing any symptoms. Rather, they should call in and speak to someone at the employer, human resources, or someone else before coming to work. It's much better if they don't come in at all, rather than working for a few hours and then reporting that they have a cough. So there's some steps that are recommended to be taken. I have a too big question and answer box. There we go. Steps that we recommend that we take. First, if someone is sitting at their desk reporting to you that they aren't feeling well and they think they may have a fever, or if you take someone's temperature and they do have a fever, you want to send that employee home. They shouldn't be in the workplace. Or if they call in and tell you that, you should tell them not to come to work. Then you want to ask that person some questions. You're going to want to identify anyone who has been in close contact with them in the immediate past. We'll go through exactly what close contact means and what you're looking for in that regard. But the guidance out there right now is that you should be doing contact tracing in the workplace. You want to identify anyone with a potential exposure and remove and isolate them from your workplace to prevent the spread. You'll have to contact anyone with close contact, but also maybe consider whether you want to notify other employees who you don't believe had a close contact, but worked in the same general area, worked in the same team, or were using the same facilities as this employee. There's some benefits to that we'll go through. You also need to do a brief investigation to identify the potential source of the infection. This would be another question to that employee. Do you think you know where you caught COVID? What exposures have you had other than in the workplace? Because there are some obligations to report positive COVID cases to OSHA. And also that information is going to be helpful to your workers' comp carrier in the future. And then you want to, once you've gotten everyone who's been exposed or who has symptoms, you're going to want to clean and disinfect the areas in which they were in the workplace. And then you're going to want to contact your workers' comp carrier, and we're going to go through a little bit about why that's important also today. So first, we'll go through what do you do with that particular employee that either has tested positive for COVID or is experiencing COVID symptoms and seeking diagnosis or waiting for a test result, for example. A positive test result most definitely should be removed from the workplace, and these things should be put in place. But also, if you're going to be cautious, you want to remove anyone that is awaiting a test result as well. So the employee, first and foremost, should be following the recommendations of their healthcare provider. The healthcare provider is someone you should refer the employee to. We can take steps to protect our workplace and our other employees, but really we're not there to give health advice to these particular employees. So they should be guided to their healthcare provider. And they should be asked to remain home and away from the workplace until they get a release from either a physician or a health official. Sometimes this is not possible because they can't get an appointment, they don't have a regular physician, or there are other obstacles. In that instance, the CDC does have some guidance for us on when an employee could discontinue self-isolation. And I believe that's our next slide. Yes. So this is for an employee who has COVID symptoms or a COVID diagnosis and when they can return to the workplace. This also, I have to say, has changed several times. So you want to stay up to date on these things. And if you do have an exposure in your workplace, you're either going to want to contact your legal counsel to get up to date on what exactly is the current guidance, or you're going to want to check at a minimum, check the CDC website to see what their current guidance is. And I've got links on the bottom of a lot of these slides so that you can navigate directly to those websites if you need to do so. So the first strategy for identifying someone that can return to work, if you're not going to require them to bring in a doctor's note, which you can do, is to allow 3 days to have passed since recovery with a resolution of the fever without any fever reducing medications and the improvement of respiratory symptoms, plus 10 days have passed since the first symptoms appeared. So this is a 10 days plus type of analysis here. They have to have both to meet the CDC criteria. So it is important that you have the employee write down and keep track of when their symptoms first began and when their symptoms began to resolve and when their last fever was, if you're going to use this strategy. And when we're dealing with, we'll talk a little later about employees that maybe only have one symptom and they don't think they have COVID, but it's also important to have those employees recording, at least for their own purposes, when their symptoms began, because employees do tend to forget that kind of thing. And if we want to return them to work without a medical note, we're going to need a record of that. The second option is a test-based strategy. So this is a resolution of fever without medications, an improvement in respiratory symptoms, and a negative result of a COVID test. So this could or may not be the 10 days plus 3 days. It doesn't have a daily requirement. Instead, they have to have a negative COVID test. So even if someone brings you a negative COVID test, but they are still having a fever, that's a potential problem and it wouldn't meet this particular test. So that's what we should do with that particular employee who has been diagnosed or is experiencing symptoms. So that person was in the workplace and going about their business as usual, hopefully with precautions in place, and they exposed other people. So what we want to do is figure out who those potential exposures were. The CDC gives us some guidance on this, and it's been fairly consistent. The amount of distance has been the same all along. The number of minutes has changed slightly. Right now it's 15. So close contact are people that the employee spent time more than 15 minutes with within 6 feet. So they're within that social distancing buffer zone. And this occurred within 48 hours before the ill employee began developing symptoms. So rather than just going back to when did you start feeling sick, who were you around, you need to go back 48 hours before that. So who were you around within 6 feet or less for more than 15 minutes? So this is not someone they might have passed in the hallway for a brief second. It may not be the person that sits next to them. If you have very strict social distancing protocols in your workplace, they might have come to work for several days and not been in close contact with any employees that would need to be isolated. But this is the information that you need to gather. It's difficult to do if your employee is in the hospital. I worked with a client that had someone who was in the ICU, so they couldn't ask these questions of them. So instead, they tried to gather it from the coworkers and other sources, which is all they could do, and they did a good job of that. But it's important as soon as you speak with the employee to get this information, because they may not be able to give it to you later. And of course, their memory is going to lessen as well. If you have a workforce that's going into apartments or going into different customer homes, you may want to keep more track of where they were than you may have ordinarily in your business practice before, because you can then trace back which customers they came into contact with or which coworkers they were working with closely, and a diverse and spread out workforce that might make things easier on you, especially if the employee cannot recall. So employees that have been exposed should, within close contact, should be asked to self-isolate. And they should remain home according to the current guidance of the CDC for 14 days after the last exposure. So if your ill employee was in the office for 3 days with a minor cough and didn't tell anyone, we go to the last exposure. So that's the day that they told you they were ill and you removed them from the workplace. But then any employees that were exposed on day 1 but didn't see him again, their quarantine would be 14 days from that last exposure. Employees should be, again, recommended to speak with their healthcare provider and deal with their specific healthcare situation. They should be asked to self-monitor for symptoms, because if they do begin experiencing symptoms, like we discussed, the return to work protocols are going to be based on when they last had symptoms. So they should be keeping track of that. And they should be keeping track of their temperature twice per day so that you can identify when the temperature is no longer occurring and they can come back to work after that, in addition to those other requirements we discussed. Employees should be advised also to avoid contact with any high-risk individuals during this period of self-isolation because it's possible that they did contract the virus. And if the employee does develop symptoms, they should let you know so that you're kept apprised of their status. That might change the type of leave you have them on. It could affect their pay. It could affect who else you advise in the workplace, and they should be told to check into the CDC guidance and contact their health provider. So in terms of notifying other employees, like those that maybe work in the same building or on the same team, but didn't come into close contact with the employee that's ill, that's not necessarily required by the CDC or Cal OSHA at this point, but there are some practical reasons for notifying those employees. One is that it gives you an opportunity to reassure your workforce that you're taking proactive steps to protect them. I have seen several incidents lately with employees who are complaining on social media that there was an outbreak in their workplace, no one told anyone, they don't want to go back, and they are now publicizing this on Facebook. So it's not good PR for your employees to be venting that you're not doing what you're supposed to. That information probably falls within protected activity because they're talking about their workplace conditions. So you wouldn't want to discipline for that. But you can proactively try and stem that by keeping them informed about all of the steps you're taking to protect them. It reduces gossip about these whispers about, I think so-and-so was sick. I think that there's something going on in our workplace. The more facts you can give your employees, the better off you are generally. And it allows employees to ask questions at the source. So rather than you hearing third hand that a particular employee has a concern or they had their own potential exposure, it opens up the door for employees to come to you directly rather than having to discuss any COVID-related concerns or issues through the rumor mill. And then it allows those who are high risk to follow up with you and to feel safe doing that. So employees who have a hidden health condition, for example, that may make them higher risk, may want to come and speak to you about that because there was an exposure in the workplace. So they might want to say, now that we've had an exposure, I think I may need an accommodation to work from home. My doctor is recommending that if there's an exposure in my workplace, I not continue to be in the workplace. So there may be some accommodations that can be addressed because you have shared information with employees. It's important to note that there is a difference in the CDC's recommendation for essential workers. So fairly early on in the pandemic, the CDC became concerned that there were outbreaks in workplaces that were essential, and it was requiring too much of the essential workforce that keeps the essential industries going, being out of work. So there's a different protocol here for anyone classified as being an essential worker. And even though the pandemic has evolved and more businesses have reopened, this remains in place because of the importance placed on critical infrastructure. So for those employees who have been exposed to a COVID positive individual in the workplace, they can keep coming to work, but they have to self-monitor with some precautions. So first, the employer should take employee temperatures, and particularly that employee, and screen for symptoms. Rather than letting them just report if they're ill, you should be proactively screening that individual or those individuals that had the exposure. The employee should still be required to self-monitor and report symptoms, even if you're proactively asking them. If they feel ill in the night and begin coughing, they shouldn't come to work and wait for you to ask them. They should call in. The employee should wear a face mask at all times in the workplace for 14 days after the last exposure. So some workplaces have flexible mask requirements. So if you're in an area in which you may come within 6 feet of someone, you need to wear the mask. But if you're in your own office where you're more than 6 feet away from someone, you do not need to wear the mask, for example. However, this is not applicable in an exposure of an essential worker. They need to wear the mask at all times in the workplace, according to CDC's guidance. Employees should maintain 6 feet of distance as work duties permit. I think that one's pretty self-explanatory. And then employers should increase cleaning in the areas in which these exposed workers are working, especially common areas such as offices, bathrooms, and then shared equipment. And they should be not allowed to share equipment to the extent possible. For example, headsets in a restaurant environment or something like that. Although it's not quite a good example because the restaurants aren't deemed essential. But if you're in an environment where your people are wearing headsets to communicate with one another, that would be an example of something that shouldn't be shared. So in addition, to removing the infected employee from the workplace, removing those with the close contact from the workplace, and then notifying anyone to the extent you want to do so. You should also take proactive steps to clean and disinfect the workplace and the work area where employees who potentially have COVID are working. So this includes, again, offices, bathrooms, and common areas, which were used by the infected employee. And there should be extra focus on cleaning frequently touched surfaces. A few weeks ago, or maybe a month or so ago, there was a recommendation from CDC that you delay cleaning if possible and instead close off the area and then clean later. The CDC's recommendation on its website this morning was to clean. There was no delay. Go ahead and clean using an EPA and CDC approved cleaning product. The guidance also says if it's been more than 7 days since that employee visited or used the facility, that there is no need for cleaning and disinfecting any longer. And there is a data sheet with each cleaning product that you should check out if you're using a new cleaner that you haven't been using before to determine the safety precautions that should be taken for that cleaner. I think on the next slide, I actually have the link to the EPA. It's not, I think I said CDC registered disinfectants, but it's an EPA registered disinfectants. And this is where the list can be found for those that have been determined to be effective against COVID. So you're going to want to make sure that you're using those to clean after an infection. And actually, if you're not using these to clean regularly anyway, I recommend checking this out because the list has expanded. So if you were having difficulty finding EPA registered cleaners initially, there are now quite a bit more on the list that have been approved. Dirty surfaces should first be cleaned with detergent or soap and water, and then the disinfecting process can occur with the cleaner that's been approved. Again, you'll want to pull that safety guide and what was it called? Safety data sheet to determine if there's any safety precautions with the product, especially if it's a product that your staff isn't using or you're not using a commercial janitorial service that's familiar and responsible for that. Anyone doing this cleaning should wear disposable gloves and gowns according to the CDC, including the disposal of the trash from the cleaning. And they should be reminded to clean their hands often, including after removing gloves. So this is the CDC link here on the bottom, which relates to how to clean after an infection in the workplace. And it may also, I think, go through just general cleaning recommendations from the CDC. So I mentioned earlier in the presentation, California's workers' compensation. So Governor Newsom fairly early in the pandemic did issue an executive order affecting COVID-19 cases and workers' compensation. The existing law was that employees had to present a reasonable factual basis for asserting that the workplace caused their injury or illness. The executive order changes that and makes it a presumption that the employee contracted COVID-19 from the workplace. Now that presumption is rebuttable. If the employee was at a party that the health department has identified had several individuals contract COVID and you have no other cases in the workplace, that is information that could be used to rebut this presumption. So you're going to want to work, there are some timelines built into this too. So you're going to, let's see, oops, sorry about that. I'm trying to get rid of the chat so I can read it. So if an individual reported to work outside of their home and received a positive test or physician diagnosis within 14 days from working outside the home, then they're covered by this executive order. Employees working from home would not be, because if they are not in your workplace, they did not contract it in your workplace. So it's important to contact your workers' comp carrier if you have a COVID case in your workplace, so that you can get them whatever information it is that they need to take the steps they want to take. There are some timelines built into this law that I can't remember off the top of my head, but that make it important to reach out to them quickly. So OSHA has changed its reporting requirements and issued a guidance with regard to COVID-19. The general rule is that any serious injury, illness, or death occurring in any place of employment or in connection with employment has to be reported by the employer to the local OSHA district office immediately. That would be if your employee was injured in a machine accident at work, or now OSHA has made it clear that this includes a COVID-19 related hospitalization or death. So if you have an illness that is related to the employment, it must be reported. So how do you decide if a COVID-19 illness is work-related such that it needs to be reported to OSHA? Well, OSHA's guidance gives us some information on that. You need to do a little investigation and make a fact-based inquiry into this COVID case. So you need to talk to the employee and learn where they think they contracted COVID. You need to determine if you have any other individuals in your workplace with COVID, and you can consider your physical distancing protocols. If this employee was isolated and off to the side and didn't come into close contact with anyone in your office or the public, it's less likely that they caught that in your office. If they are a grocery store clerk, it's more likely that they potentially caught it from the public because they're dealing with customers on a revolving basis. And what I have been seeing recently in my practice is that there's one individual who tests positive for COVID, and they potentially know where they contracted it outside of the workplace because they have other family members with the illness or friends with the illness that they were in close contact with, and they're pretty sure that's where they got it. And there's no other cases in the workplace. They're the first one. So that's probably not a work-related COVID case that needs to be reported, because you've gathered facts that lead you to believe that it was contracted elsewhere. Now, they don't have to know someone else in the workplace someone else at home that gave it to them. They could have caught it at the grocery store for all we know. But the fact that you don't have any other cases in the workplace is good fact-based evidence. Now, unfortunately, several of my clients have then developed a second or third or fourth case in the workplace. So especially part of that person's team. So those second, third, and fourth individuals may have a workplace related exposure because they caught it from the first employee who caught it from his cousin. I have a question here I'm going to look at real quick. We are a nonprofit singing group. Should our singers be considered employees? So your obligations to employees are different because of the Cal OSHA standards and because of your obligations as an employee rather than a membership group where you don't have that employee-employer relationship. But there are still, I think, best practices in terms of dealing with the public or other individuals. There may be some liability to members for a negligence standard, for example. They would not necessarily fall within Cal OSHA. They would not necessarily fall within workers' comp. Who is or is not an employee is a tricky question that I don't want to get into. But the problem with some of these exposures is that it applies also to customers. So if you had a customer who had a positive case and they came in to meet with one of your employees, even though that initial exposure was not an employee, the employee's exposure may have been. Or if your employee tested positive and then met with a customer, you're going to want to notify that customer. So the next question I have is, we share an employee for 10 hours a week with another employee. What is our potential exposure? So if that is in fact your employee and there's a joint employer relationship or an employee sharing relationship, you have the same obligations to that person as you do to your other employees. They're potentially, however, getting exposed from another workplace, but that is very similar to an employee who catches the illness from a roommate, for example. There's still a potential exposure in your workplace. When we're dealing with employees that go out to your customers' sites, it becomes a little bit harder to enforce your social distancing protocols and your safety mechanisms. But that's a discussion you're going to want to have with those sites and with your customers about how they can potentially protect your workforce. And if they are creating a dangerous environment for your workers that is not an inherent part of the job. Of course, healthcare providers are exposed to potential illness from their patients. But if that's not an inherent part of your workforce, you need to reconsider that relationship and engage in a dialogue to create a safe workplace both in your office and at your client sites for your employees. Oh, and one note, some employers, manufacturing employers, industrial employers, those with heavy machinery, and that are in higher risk environments do have log requirements, and COVID-19 may qualify as a recordable event if the employee is receiving treatment, was hospitalized, or receives a diagnosis. So if that is you, do consider that as well. Most office employees do not have, most office type employers do not have log 300 requirements. Also, the San Joaquin Health Department, in a memorandum of April 16th, indicates that employers should report outbreaks to the county public health services. Now, you don't have an obligation for an individual exposure to report that. An outbreak is considered to be 3 or more lab confirmed cases from unrelated employees who aren't living in the same household within 2 weeks. So hopefully this is quite rare, but the county public health services is asking that employers report these outbreaks. Now, whoever your employee is getting tested by, whoever their physician is, they do have their own CDC and health department related obligations. Those aren't your obligations, but this is a specific memorandum from the San Joaquin County Public Health Services Department. So employees who test positive for COVID or who are having COVID symptoms and are taken out of the workplace either by you or by their doctor do have a lot of leave rights right now. And we'll go through those in a moment. I just have another question I want to look at quickly. This question says, are women over 55 still at high risk? This particular shop is not opened due to volunteers being over 55 and into their 80s. I did not look that up this morning. The California Department of Health website, however, does have a recommendation for those who are at high risk and does identify those who are at high risk. I believe it still does. Well, it includes people with a lot of different illnesses, but I don't remember what the age threshold is currently at. But that is something you can look up. It has changed over time, so you do want to see what's current. But the recommendation was previously that those individuals stay home, regardless of any kind of stay-in-place order. So I would check the California Department of Public Health website for more information on the current recommendation for those at high risk. So this slide here addresses California's COVID-19 paid leave. And it's on, the link is at the bottom on the Department of Industrial Relations website. This is just the top of the chart, but it is a very nice chart that goes through all of the different types of California paid leave, or paid leave in California, I should say, because some of these are federal. But this is important to share with your employees so that they don't come to work if they have COVID symptoms. A lot of people don't want to be out for a minor cough. But you don't want them in your workplace during the pandemic, of course, because if they later develop more symptoms or test COVID positive, that's more people that they potentially expose that you then have to ask to self-isolate. So share these resources with them and become familiar with them yourselves so that you're aware of what kind of paid leave is available, even if it's not employer paid leave. We're going to go through some of these specifically, though. Okay, I got another question that I was just reading. Can an employee not report to work even though she has not reported any symptoms, including a temperature? How do we pay her salary and how many days? I think we're going to answer that question as we go along. So I'm going to hold off on that one. And if I don't answer it, let me know and I will try. Okay, so this is from the DLSE website in California, the Department of Labor Standards Enforcement, which is the Labor Commissioner's Office. They list on their Q&A that essential workers can use paid leave if they can't work because of the stay-at-home order. Sorry, non-essential workers. Essential workers, that applies to very few people at this point in time as we've reopened. Essential workers can use their paid sick leave if they or family member are sick with the illness, including a potential exposure, if they're 65 years or older, if they have a chronic medical condition, or they're caring for a family member who has a suspected exposure. And this 65 and over was the original, I didn't pull this down off the website this morning, this was the original recommendation for high-risk individuals. So if that has changed, I recommend looking that up, but this was the sick leave recommendation for high-risk individuals. And employers, however, cannot require their employees to use the California sick leave, but you can require them to use it in a 2-hour increment. So if they need to use sick leave for 30 minutes in the morning, for example, you can ask that they use it in a 2-hour increment instead so that you can adjust your schedule. The Families First Coronavirus Response Act is, I think we're all familiar with now, provides paid leave for all employees. Basically, there's some exceptions that we'll get to in a moment, who are affected by COVID. And the requirements are someone that is subject to a federal, state, or local quarantine or isolation order, someone that has been advised by a healthcare provider to self-quarantine related to COVID-19, someone that is experiencing COVID-19 symptoms and is seeking a medical diagnosis, someone caring for an individual, or self-quarantine, and then we have the childcare aspects of this. So the individuals who may have been sent home by you because they are coughing in the workplace or they reported a fever can potentially use and qualify for FFRCA leave. This is reimbursable out of your payroll tax liability. There are some caps on the wages. It's not necessarily full pay. Paid sick leave is limited to $511 per day, or $5,110 total for the worker's own care, and $200 per day, $2,000 total for caring for someone else who's ill. There are some restrictions on this. You can't require an employee to use some other type of paid leave first, like your own PTO policy, for example. You can't require the employee to find a replacement to cover their scheduled shift. There are reinstatement rights under this, with an exception for someone with less than 25 employees who eliminated the position due to economic conditions. And there is no retaliation for someone who uses this leave. The exemptions are pretty narrow and require a pretty high standard. The first is financial hardship. So if letting that employee take this paid leave would result in the business's financial obligations exceeding business revenue and would cause the small business to cease operating at a minimal capacity, you can deny the request for FFRCA leave. If that individual employee is particularly critical to the business because of their level of skill or knowledge and key to the operation of the business, there's an exemption for them. And then if the individual that asks for time off is not particularly skilled or essential, but there just isn't anyone else to do their job that's willing or able or qualified to provide the services you need, and those services are necessary to operate at minimal capacity, that is the third exemption. So if you aren't going to allow leave, I recommend consulting with your attorney. This is the area of greatest liability exposure at this point in time. And this is the area in which we're starting to see lawsuits and claims. It's for failure to provide necessary and required leave of absence, failure to accommodate disabilities relating to COVID and higher risk individuals, and failure to properly grant leave and paid leave. Which brings me to the next slide. Just because we are focused right now on COVID, again, the FFRCA doesn't mean there aren't other leaves that may apply to this individual. Pregnancy, disability leave, and new parent leave still exist. They still apply to our workers. The ADA and Fair Employment and Housing Act require you to accommodate a disability, which could include a leave of absence. And so those are each types of leave that should be evaluated and granted to the employee if they apply. The ADA VHA leave is especially, I think, relevant in this era of COVID and its pandemic, because there are individuals with health conditions that you may not have known about because they're a hidden disability and they just didn't present an issue in your workplace previously, but now they place that individual at higher risk, and that employee might not be able to return to the workplace. And then we have our other leaves that are less common: organ donor and bone marrow leave. I've not listed every leave here on the screen. It's a very long list in California. But then you also have your own policies that you should be enforcing and following consistently across your workforce. If you have bereavement leave, for example, or if you grant additional personal leave for some reason, you want to make sure to apply those in the COVID situations. So that is the last slide with substantive material that I have for you today. I have some frequently asked questions that I thought would be helpful to go through. But if you have some additional questions, please let me know. Let me just check my Q&A and chat boxes real quick. Oh, the question is, do essential workers have to take temperatures now? That slide I went through earlier about taking essential worker temperatures was for essential workers who have been exposed to COVID in the workplace, but who don't want to go on a 14-day self-isolation for whatever reason, either your choice, probably your choice, in fact, to allow them to continue working because they're an essential worker under the CDC's requirements, you have to take their temperatures. But just generally, outside of that exposed worker, essential worker context, the California guidance out of Cal OSHA, the reopening roadmap documents recommend or require employee screening and or temperature checks. So most employers that I've spoken with are either asking their employees to take their own temperatures every morning before coming to work, or they're taking temperatures in the workplace. Just one note on that. If you're going to be recording new information about your employees, temperatures, health screening questions, and you fall within the California Privacy Act that went into effect this year, you need to make a disclosure to those employees about what kind of information you're maintaining on them and what its purpose is. And the purpose can be to screen for COVID, which is fine, but there just has to be a disclosure. And your counsel should be able to provide to you that kind of disclosure form. We do forms for employee self-certifications. We do forms for employees who are returning to work. We answer a lot of paperwork questions right now and can provide you anything that you might need. So the first one I have here on the list is, what about a suspected but not confirmed case of COVID? The recommendation is currently, I think the best practice is to treat it like a confirmed COVID case. If it turns out that it's not a confirmed COVID case, that's great. But then you potentially have less people out of your workforce. And you can follow those timing requirements that we went through on the prior slides. The next one, what if an employee is exhibiting COVID-19 symptoms but does not think they have COVID and they want to continue working? So this is coming up quite a bit now. Excuse me. Now I'm exhibiting COVID symptoms. No. It feels like that sometimes. So say someone just develops a cough, but they have allergies. And so they think the cough is allergies. You can ask that, you should ask that person to go home until their symptoms subside. You can ask them to bring a doctor's note to come back to work, or you could put in place what you feel is a reasonable screening procedure in line with the COVID-related screening procedures, or waiting 24 to 48 hours until after the employee is no longer exhibiting those symptoms. That gives you a chance to determine whether they develop any more symptoms and for them to contact their own healthcare provider. We don't have a lot of very clear guidance on this scenario. And so there's a range of responses from the most conservative to the least conservative. But a COVID symptom, I think, should be treated seriously, and you shouldn't have anyone in your workplace with COVID symptoms, even if they don't think it's COVID. What if an employee's spouse was exposed? I get this one quite a bit. So this employee's spouse was exposed in the workplace and their COVID-19 test is pending. Again, this is one where we don't have a lot of clear guidance from the CDC or Cal OSHA. But I think the most common recommendation I've seen in this scenario is to ask that employee to remain home and to self-monitor and to self-isolate. And then if you receive additional information that they are developing symptoms, or that their spouse actually tested positive, or that they test positive, then you take additional steps to isolate and notify others in the workplace. I have another question. What are the laws about an employee returning from leave? Are we required to give them the same job with the exact same duties? The FFRCA leave does require return to work. 1 second, get there. It does require reinstatement. There are some specifics about what that reinstatement means, especially in the context of a workplace that may have been reorganized due to economic conditions. That's a question I would ask if you cannot put them back in the same position. That's a question that I would get a legal opinion on, because that is a very hot area for litigation right now. What type of HIPAA rules do we need to be concerned about when sharing that we have an employee with COVID-19? So these rules have not been relaxed. You should not disclose the identity of the individual that had been diagnosed with COVID. Instead, you should just inform the employees as minimally as possible that someone in the workplace has been diagnosed with COVID and that you believe they have been in close contact with them. If there shouldn't be, I haven't experienced a situation in which any more information than that was required. I have seen some employers getting waivers to notify other employees. That may be necessary in a very small workplace, but really the privacy should be paramount and maintained to the extent possible. Now, I've also seen employees who go and tell all of their coworkers before they tell human resources that they were exposed and exposed them. And then you have to kind of follow along and clean that up. That's happened several times, but if the employee discloses it themselves before you have a chance to protect their privacy, there's not much you can do about it. But you do need to be very careful about privacy rights. Are we to pay the employee's full salary who is self-isolating while the spouse is getting tested? They would potentially, I was going to say they would qualify for FFCRA leave, but they don't have symptoms and they don't meet those criteria. They could receive any sick leave potentially, or any paid leave that you offer. That one is a little tricky. I don't think we have clear guidance on that. I would consult with your legal counsel about your individual policies and the specific circumstance of that employee. For example, if they were out of paid leave, it wouldn't qualify, but okay, I think I've answered all of the questions. We have a few more minutes, so I'm going to go through a couple more. What if the employee is in the high risk category and you have a workplace exposure? So this is one that brings up the issue of disability accommodation. So, and I touched on this briefly already, which is that you probably have employees in your workforce that have health conditions that may or may not qualify as a disability, but that make them high risk, and that mean that they need to be taken out of the workplace due to the exposure when they might otherwise not have been. So that's something you're going to want to work with your counsel on, and that individual employee to identify if there is an accommodation that you can offer and what it might look like. Can you require employees to get COVID-19 tests? Yes, the CDC and the EEOC are approving tests for current COVID cases. They do not allow antibody testing. So there's a difference there because of the reliability of antibody testing right now. It's not that reliable. It's not considered to rise to the same standard of impacting health and safety of the workplace and presenting a present danger in the workplace. So there would not be an ability to require employees to get antibody tests at this point in time, but you can, if you have an exposures in the workplace or they're treating patients, for example, if there is a need in the workplace for a COVID-19 test, that is something that is possible. Now, this does get into the area of different privacy rights, so this is also something you might want to run by counsel, but there is some guidance from the EEOC that it is permitted in certain circumstances where there's a danger. Can I discipline employees for failing to wear a mask? So this has changed because there's now a statewide order on masks that requires them in a lot of workplace environments, or almost all workplace environments. Um, so the answer to that is potentially yes. You do want to make sure that that individual does not have one of the exceptions that would prevent them from wearing the mask, that they do not have a health condition that would otherwise make that unsafe for them. You can come up with some alternative solutions, potentially one of which is face shields. So that's something you want to tread carefully on. There's also the personal and political preferences of your employees to take into account with that, with regard to people management. But the Cal OSHA requires that you not only have a plan in place to protect your workplace, but that you're also implementing it. And so one of the things they're going to look at if they were to come out and do an investigation or an inspection is whether the plan is actually being implemented. So if you have a very nice site-specific workplace plan in line with California's Cal OSHA guidance, reopening guidance, and it's in a drawer, and you've not shared it with the employees, and you're not enforcing it, and you're not adapting it to the current circumstances in your workplace, that's going to be a problem for you and then create a liability for you. So employees who are not complying with your COVID-19 precautions should be disciplined so that you can establish that you've done what you can to keep the workplace safe, because just having a rule and not enforcing it is not sufficient. So employees that report to work knowing they have symptoms, at 10 a.m., you should not learn that your employee has a cough. That would be a violation of your policy. Employees that aren't wearing masks, that aren't maintaining social distancing, that aren't using the protective equipment you've given out, or that's required, all of those things should be considered for discipline, so that the plans that you've put in place are actually being carried out. And I hope that through the presentation, you have seen that by putting those things in place, you're really limiting potential exposure down the line, not only from exposure and then having to potentially self-isolate a lot of your employees, but Cal OSHA reporting, workers' comp cases, and other potentially expensive aspects of business in this pandemic. Do employers need to provide employees with masks? I would say yes. In California, there are very rigid requirements for personal expenses relating to work. That may have changed with the statewide mandate, but I would have masks available rather than sending someone home for not having brought a mask, rather than facing a potential claim that they weren't properly reimbursed under the labor code for the expense of masks. I would provide them, or allow the employees to bring their own potentially if that works for your workplace and the type of work you're doing, but then make them available as well. Okay, we just have a couple minutes left, and if there's any other questions, I'm happy to stay around and answer them. If you want a copy of the slides, I am happy to provide them. I can't guarantee that the information won't be out of date next week as things evolve, but please email me and I will go ahead and send you a copy. I don't usually post the slides online because they get out of date so fast, but I will be putting a copy of this presentation online, assuming my recording worked. It will be on my firm's website. I got another question, 1 second. If you are putting your email in the chat, that disappears when I end the presentation. So if you could email me instead, I'm going to go to the slide with my email address. That is much better, because otherwise I might lose that request, and I really don't want to. I want everyone who attended and wants a copy to get one. We have a policy that asymptomatic employees who are waiting for test results are to return to work as long as they are wearing a mask full time. What are our options if an employee states he is not comfortable doing that? So this is a question that you might want to run by your counsel, because there are a lot of factors that go into this. One, I think the guidance is probably different if those are essential employees. Two, I think that it really depends on why the employee is getting tested and what service you are providing to the public. There are a lot of factors that go into whether that is a good idea or not. And then aside from whether you're allowed to do it, I think there's the other consideration, which is it a good idea in terms of employee morale, in terms of setting a precedent going forward? There's a difference between letting your favorite employee who is a top performer stay home for that and someone else. Also, when you're asking employees, I should have noted this before, asking employees to self-isolate, if they can work from home, then they don't need to be placed on FFCRA leave. That is for someone who's not able to continue working. Same with sick leave. If they aren't feeling ill and they're able to be working remotely, you just have them work remotely. Okay, I don't see any more questions. Of course, if you have one afterward, please feel free to email me and I will try and answer it if it's about the presentation material. I wish you all the very best of luck in navigating all of these issues. It's easy to talk about the legal implications and the rules, and it's a lot harder to actually be dealing with employees that are facing serious illness or financial strain. So good luck, and I hope to see you at the next webinar.